Infatti, perché non riuscivo a entrare, ma sono entrata. Non so cosa sia successo intanto, nel tempo che mi sono fatta un caffè.
Good afternoon to everybody. Can you hear me?
Yes.
Okay,
yes, good afternoon.
that's fine. Just to see if everybody, 42, some are missing, but I hope they join the meeting soon. What shall we be doing this afternoon, this lesson. We will be finishing the part devoted to criminal law and procedure. Then we will move on to a short part devoted to criminology, which I think is important, that you have an idea of these kinds of approaches also that are not strictly only legal. And then we will move over to something that is connected to what we have been discussing these days, which is the issue of jurisdiction. But that is a different module of our course. Now, just to resume, to go back where we were yesterday, let's see if this time. So just to point out what we were doing, just let me get this slide, put it at the center, then take this away. Just let's go back a second. So we were looking at, sorry, the number of the slides, I must correct them. We were looking at the notion of sanctions and how these sanctions work and these anticipatory sanctions work. Now this is, I just want to draw your attention to this issue. You are lawyers, we are lawyers, and so we are focused on the rules of the law, and we must know these rules, we must know them very well, how they work, and interpret them correctly. Otherwise, we are doing a different job. It's not, we're not doing our job. But at the same time, we must not, as lawyers, ignore what happens in the outside world. The lawyer's world is not only what is in the books, in the codes, in the law, in the case law, it's also in what happens and what happens around the world. I mean, just think if we were just considering the law without thinking that millions of people are on a lockdown, that tens of thousands of people have been killed in this coronavirus pandemic. So we cannot ignore what happens outside the law. Social, natural phenomena, political events, we cannot ignore them. So just to show you that this is a point that we must keep always keep in mind. Now, just to look at go on with the comparison with the different models. When we are talking of the sort of the control over the exercise of power by the public authorities, we see that there's been constantly, the issue has been that of trying to give this kind of control to an independent entity, the judge or the courts. And if you remember, one of the slides we saw yesterday or on Monday, when we were looking at the Habeas Corpus Act, the English Habeas Corpus Act of 1689, it says the sheriff is obliged to present the arrested person in front of the court and to explain the reasons why that person has been arrested. Now, what does this mean? That constantly we're trying to, we have been, throughout the centuries, we have been trying to establish forms of control over certain police activities. Just let's make an example. Over the last 20 years, since the 9/11 terrorist attacks in New York and the US, and subsequent terrorist attacks in Spain, in France, in Belgium, in Great Britain, in Germany, since we have been very much concerned over the problem of security and public safety against terrorist attacks. Now, how do you discover terrorist attacks? What kind of investigations you must do? Can these investigations be somehow subject to a kind of judicial control? So this is a very delicate issue. I will not enter it. Very complex problem, because you can easily understand that when it comes to a terrorist threat, the problem is not obviously trying to investigate after the fact has happened. Once the terrorist attack has been brought to conclusion, and generally what happens is that the terrorists, those who have perpetrated the attack, are killed. It's a suicide attack, so there's nobody you can you have no person you can accuse. And anyhow, the problem is not that of having a trial 1 year, 5 years, 10 years after. The problem is prevention of terrorist attacks. This creates a very complex issue on what are the powers of the public authorities that these public authorities can put into place to avoid terrorist attacks. So it's all preventive. So to what extent must the action of the police, secret services, informants, and so on, what is the control that the judiciary, the courts, the judges have, must have, may have over these kinds of activities? So this is a very delicate issue because, and it has been very delicate in the US, but also in Europe, because there are some fundamental guarantees. The fact that, for example, I have a name which is an Arab name, and I've been traveling to the Middle East, does this make me automatically someone who is suspected, and that I can be controlled in all my movements, in all my relationships, in the people I meet, I speak to, all my phone, my computer can be controlled to know if by any chance I am involved in a terrorist network. Just to point out that this tells you that this issue of preventive control, and to what extent this control can be made without a judicial supervision, is one of the main issues of our contemporary democracies. We are very concerned about public security, but at the same time, we want our freedoms to be protected. We don't want, as we know, that one of the main aims of terrorist attacks is to destroy our democratic system, our open, pluralistic, free democratic system. So the problem is, when we introduce certain rules, well, everybody asks himself or herself, are those rules proportionate? To what extent are we renouncing to fundamental freedoms in order to protect public security? So we always have this issue of balancing. So just to point out that this problem of controlling what police, I'll put it quote unquote police anyhow, public authorities are doing in order to prevent crimes, to investigate crimes, is a general issue which is ever more relevant in these turbulent times. So the issue, and I've somehow put it to you, is can the police authorities act ex officio? Can they just anybody, a policeman, thinks that there's something fishy going on somewhere and starts investigating himself on what is going on? Or does that the police authority, I'm using a very broad notion because police authority, depending on each state, they can be of various level. Does this police authority need some kind of judicial cover, authorization, and to what extent is this kind of authorization absolutely necessary? Just think of a policeman who off duty starts investigating on certain crimes. Certain crimes have not been solved, and the policeman off duty starts investigating on these crimes. Can he do it? We would say obviously no, because the policeman cannot investigate on crimes if you have not been somehow, this investigation has not been authorized by the judicial system, by a judge or public prosecutor. Surely he cannot do it when he's off duty, but can he do it when he's on duty? While he's on duty, he starts investigating. So we start discussing on what are the powers of public authority to investigate, and this investigation can bring up very relevant facts. They might be not crimes, it might be something completely different. So the problem is, what are the limits of the investigation? So this is the first point that I wanted to make, the fact that the relationship between the authorities that are there to investigate crimes and prevent crimes and the judicial control over the activity of these law enforcement agencies. So this is a very important aspect in modern democracies, and which generally is regulated by criminal law and procedure, which says when, in which cases the law enforcement agencies may act and what are the limits, the scope of their action. Then again, we must distinguish when we are talking of investigation, that is discovery of elements of evidence of a crime. So that is of a crime that has been committed or that might be committed, as in the case of a terrorist attack, which has not been yet put into place, and instead the use of coercive measures such as limitation of physical freedom of someone who is accused. And here we notice also the very delicate issue, and I won't go into it, but just to point out to what extent can law enforcement agencies control sort of digital technologies. There's a typical issue which I've already mentioned to you when we were looking at the Fourth Amendment to the US Constitution. Unreasonable searches and seizures. Now, what is the one typical example? There are many cases in the US that are very careful on the respect of the Fourth Amendment. So someone goes around with a computer and the police stops this person, and can the police inspect the computer? So to see what is held in that computer. Let's imagine in that computer, let's take a typical crime, which is a digital crime. Let's imagine that there are pedopornographic child pornography are held on that computer. Can the police somehow search that computer or seize it? We see this happens quite often, and there are many cases in the US when there's someone who enters the US with a computer and the custom authority says, hey, I want to inspect, I'm not going to inspect only your luggage, I'm not only going to scan your body to see that you're not holding arms or other drugs or whatever not, I'm going to inspect your digital belongings. So can you do this? So this is just one point. And in the US, I just like to add this. Just keep in mind that the Fourth Amendment in the US, the principle is that the Fourth Amendment applies only to US citizens. So if you are a foreigner that is entering the US, the Fourth Amendment does not apply to you, and therefore customs officers are, US customs officers are authorized to disregard the Fourth Amendment and to search and seize your digital equipment to see if there's anything that could be relevant and could be evidence of a crime. So just to point out that this is a very, this problem of investigation, as you see, is a highly complex issue. Then further, when we're talking of judicial authorization, now again, systems, and we shall see this, especially when we're looking at the next module devoted to jurisdiction, what I would like to point out, that it is not always, it's not regulated in the same way. What do we mean by judicial authorization? Is it somehow ordered by the public prosecutor? And this depends obviously on the role that the public prosecution has in each legal system. It is not the same. We have one model in Italy, which is somehow similar, but not altogether, to what we find in other European countries, continental European countries, and the role of public prosecution in the United Kingdom and in the United States. So we have different models. So when the law enforcement agencies do investigations, or they take restrictive measures such as an arrest, are they acting under the authorization of the public prosecutor? The public prosecutor has told them to do this, or have they been, are they operating under the authorization of a judge, that is a third party? Now, this is a very complex issue, because if we are concerned with individual liberty, we want to know what are the procedures by which everybody's individual liberty can be somehow restricted, and can be somehow, some person can be arrested, can be his house can be searched, and so on. Just to point out that this, again, depends very much on the system and on what are the powers of the law enforcement agencies, and what are the, when they need an authorization by some external entity, and which external entity can authorize the law enforcement agencies to investigate or to arrest someone. So this clearly, as I've mentioned, this has very much to do with the kind of relationship that we have in between public prosecution and the judge. Now, just remember, let's go back to Beccaria, because Beccaria has said more or less everything, and so it's always useful. Let's see if I find. Yes, here we are. Now, just to remember what Beccaria says, principle of justiciability, the fact that the sovereign can only make general laws to bind the members, but it belongs not to him to judge whether an individual has violated the social contract. For in this case, there are two parties, one represented by the sovereign, who insists upon the violation of the contract, and the other is a person accused who denies it. And at that point, Beccaria adds, it is necessary then that there should be a third person to decide this contest, that is to say, a judge. So we have sovereign, the state, let's say public authorities, which claim that there has been a violation of the law, and there's the accused person, and then there's a judge that must decide. Now the problem is, what are the relationship between this accusation, which is brought by the sovereign, in the 18th century was the sovereign, now we're talking of the public power, and the relation and the judge. So if you look at this at Beccaria, it is very clear, the idea is very clear. The sovereign is one side, the accused person is the other side, and the judge is in the middle. Now, if we look at most continental European systems, and this is why I want to compare them, sorry, let's get back to the slide. What is the relation between the public prosecutor, the person who brings the accusation, and the judge? Now, we have two models which are very distant one from the other that we have to keep in mind. One is the historical Anglo-American model, in which the public prosecutor's office is completely separated from the judicial order. If you have, and I trust you have seen Law and Order, which is the Bible of anybody who wants to learn about how judicial system works in the US, knows very well the difference between the judge and the public prosecutor, and knows very well that the public prosecutor is someone who's outside, has different offices, is not nowhere near the courthouse, and often the chief prosecutor is someone who's elected. Someone who's been elected, has run for election, then obviously all the people that help the chief prosecutor are not elected. They are hard, but they're hard. They are lawyers who are hard to do this job. They might be working for this for 2, 5, 10 years, and then they decide they want to do something else, go in a different state and do something completely different, for example, doing practice in lawyers. So just to point out that this is a typical model in which the public prosecutor, that is the sovereign that is accusing the subject, the citizen, is outside, distant from the judge. And the judge will be equally distant from the public prosecution and the defense and the defense. So that is one model which is very clear, and the theoretical point of view is clearly put out in Beccaria's writings. If we look instead at the, sorry, here we have repeated this. While instead in the continental European model, and this means most of continental Europe, prosecutors are part of the judicial order. So sometimes they're completely independent, that is the Italian example. Other times they are dependent from the Ministry of Justice, and that is the French model. But they are independent, they are somehow related, they belong to the judicial order, and they have a strong relationship with the judge. That to make it clear, physically clear, their offices are in the same building where the judges are. So there's a constant dialogue. While lawyers, practicing lawyers, do not have their offices in the Palais de Justice, let's use the French expression, the public prosecutors are there. So obviously they meet, they encounter, they discuss out of informally what may be questions, issues. So while this would be something completely improper in the Anglo-American model, where the public prosecutor would never be able to go to and have a dinner with the judge and start discussing the case with the judge, in the continental European systems, we see that there's very strong professional relationship between the judge and the public prosecution. So this creates two very different models, and also this, when we start discussing of the fact that the judge is actually a third party, well, we're not altogether convinced that in this system, the European continental system, the judge really is a third party, because he probably knows, he or she knows very well the public prosecutor, and they have gone to the same, they have followed the same curriculum, they have grown together, and then at a certain point they have split. One has become a public prosecutor, someone else has gone in, has been a judge. But this creates a sort of a preferential role of public prosecution in respect of the defense lawyer. So just to point out that this is extremely significant. Then I'd just like to add a few other issues which have to do very much when we are looking at when investigation of crimes. And here again, we see very much sort of differences in various models. Does the public prosecution have discretion in the choice of crimes to investigate? Let's imagine a very simple operation. In the public prosecutor's office, there are 10 public prosecutors. The conscription in which they have to operate is pretty big, and so obviously they have a certain amount of time they can devote to investigating the cases. And so obviously they having limited time, they say, well, we will investigate certain crimes, and we will not, we will prefer certain crimes to others to investigation. So, or otherwise you say, well, the first come, first served. If a crime happens and is reported to us, we will investigate on that crime. If some other crime comes after, well, if we are not able to investigate it, well, we'll investigate it later on. So you see, this is a very complex issue in which we have to discuss about what are the priorities in investigation by the public prosecution. Can the public prosecution establish certain priorities? We will look more at organized crime, or we will look at white-collar crime. That is, let's imagine financial people who are financial in Wall Street, they're committing some kind of financial crimes. Shall we concentrate on environmental crimes because they're industries that are committing very serious pollution, or shall we investigate on corruption, politicians who are corrupt, or businessmen who are bribing public officials? Shall we protect weak individuals, typically women who are the victims of domestic violence, or shall we protect more public health? So we go around in restaurants and in factories where they produce foodstuffs, and we will investigate if they're done properly. So just to point out that as the amount of crimes has increased incredibly, well, there's the problem of deciding if the public prosecutor can decide or cannot decide whether to investigate a certain crime. Then, and here we'll move towards the end of this analysis of the criminal law and procedure, I'd just like to point out on the role of evidence. Now, just we talked yesterday about the notion of beyond a reasonable doubt. So the judge, in order to, or judge or jury, in order to establish that a person is guilty, must go look at the evidence and see if the evidence is reaches this, overcomes any reasonable doubt. So we have two models again. We have this adversarial model, which is again the Anglo-American model, in which, for example, again, I refer you to all the legal movies, legal thrillers, and legal TV series that you have seen, cross-examination of witness. So there is a witness, and then there's a public prosecutor does certain questions, and the defense lawyer puts other questions. So just to point out, cross-examination, trying to have the witness fall into contradiction and therefore show that the evidence of the crime is not robust, or instead that the alibi is not standing, and therefore the witness is not a credible witness of the alibi of the accused person. And again, if we have technical matters, just think of a case in which we have to establish, for example, if let's imagine some technical ballistics. Let's imagine whether the bullet that hit a certain person, that killed the person, came from a certain pistol. Therefore, we will have ballistic experts, one designated by the public prosecutor, the other designated by the defendant, and these two expert witnesses will battle in court, one saying, yes, surely I can demonstrate, I will demonstrate the bullet came out of the pistol, that of the gun that was held by the defendant, and the defendant will try through his expert witness, will try to demonstrate that no, that bullet could have come from any gun, from many other guns, and not from, and therefore not necessarily from his gun. So this is a typical example in which there's in court, there's a battle between not so much witness, but expert witnesses. So people who are expert in ballistics, forensics, what is the cause of the death of the certain person. So these experts in legal medicine, in forensics, will come along explaining and giving each the version of whether the person was poisoned, or if that is of the public prosecution's theory, or instead the defense theory that no, the person died for other reasons which had nothing to do with the meal that person had with the accused. So just to point out that this is a typical model which we call adversarial, because the parties are there in court fighting one against the other, and the judge is in the middle and will decide, or the judge or the jury will decide, having listened to witnesses and to expert witnesses and to the exhibits that are provided to the court. Instead, if we look at let's see, in the inquisitorial model, which is more the continental European model, we have a much stronger role of the judge. While in the Anglo-American model, the judge just listens. He will just say whether someone can say, put certain questions, will decide if the evidence is admissible, and therefore he is the gatekeeper of evidence, but his role is, his or her role is substantially limited. In the continental European role, we see that the judge, the court, is much more active and directing the parties, saying, well, but you haven't clarified this. Can you please clarify this point to us? We want to know this point. While this would never happen in a sort of in Anglo-American adversarial trial, because if someone does a mistake, the court will not intervene and will not say, oh, but I haven't understood. If you are not able to explain your case, whether it is the prosecution's case or the defendant's case, if you're not able to explain it, well, that's your problem. If I haven't understood it, if the jury has not understood it, well, that's your problem. It isn't my problem. I'm not going to mend your misgivings in your strategy, your prosecution strategy, or your defense strategy. Here, instead, in the inquisitorial model, the court is much more demanding. It asks, he wants to know much more what is going on, what is, what are the elements that the parties are bringing to the court if they're not clear or not. And especially while in the US and in England, we have court-appointed experts. In the case that I've mentioned, the fact that there is ballistic expert to decide, to establish whether the bullet has come out of the gun held by the accused person. Here we see that we have court-appointed experts. So it is the court that asks an expert to verify and to refer to the court and tell what is the expert opinion of this court, of this expert which has been appointed by the court. As you see, it is something quite different from the Anglo-American model. Then a further distinction that we should keep in mind. If we look at Beccaria had this idea that generally when it came to serious crimes, because obviously he had gradation of crimes, just remember, crimes against the crown, subversion of the institutions, crime against life, property, and honor, and then a violation of other laws. The idea that someone should be judged by his or her peers. That is, that the community should judge the accused person. Now, this idea of the jury, which has historically this role of the members of the community which decide if someone is guilty or innocent. Now, this is only, we find this in the US Constitution, in the 6th Amendment. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury. And as a matter of fact, in the 8th Amendment, that is applied also to civil cases which have a value of more than $20. Now, $20 in 1791 were an important sum. Now, obviously, they're nothing. But so the idea that at the end of the day, the innocence or the guiltiness of the guilt of the accused person is decided by a jury is a constitutional principle. And this is very important because this, we see that this has very much to do with then certain lawyers who are very specialized in selecting the jury. It's a famous case of, well, more or less 30 years ago, nearly 30 years ago, so-called O.J. Simpson case, in which this famous American football player was accused of having killed his wife. And as a matter of fact, there were two cases. There was a criminal case and a civil case. In the civil case, the court ascertained that O.J. Simpson was liable for the murder of his wife. In the criminal court, he was acquitted because his lawyer, famous Professor Dershowitz from Harvard University, managed to select the jury in a certain way because O.J. Simpson is colored, and therefore, so to select somehow a racially, let's put it, ethnically favorable jury, which ended by declaring that there was not sufficient evidence to show that O.J. Simpson was responsible for the murder of his wife. So just to point out that this issue of the trial by jury, what is this idea that the jury in the American system, where it is a constitutional issue, the jury is the judge of the fact. So the jury looks at the facts and decides whether, beyond a reasonable doubt, the accused person can be held guilty, or if there's not the evidence does not bring you beyond that reasonable doubt, then the person must be let go, must be declared not guilty. While instead we see that in other legal systems, most in the European continent, we see the trial by jury is limited to very few cases, generally very serious cases, murder, intentional murder, and then we will find a jury. But generally speaking, we find that the decisions in criminal cases are taken by a professional judge, or by a court, which is formed by professional judges. Then finally, and this is what I want to conclude, we have seen historically that the person who was, historically this goes back, way back to the Middle Ages, the person who had been found guilty by the court, the judge, whatever that judge was, had the right to appeal. In those times, you could appeal the king, the sovereign, and the sovereign could somehow pardon the person or instead have a new trial, because those times criminal procedure was very much left to the discretion of the sovereign. Here instead, in contemporary and modern contemporary societies, we have this principle of the right to appeal. I'll put this between quote unquote, right to appeal. Now, this is a very delicate issue. So there's a first instance and then there's an appeal instance. So we have two instances. And so the first issue is the appeal. Is it a new judgment in which the judge of appeal re-examines all the case, the facts and the legal elements of the case, or is it only an analysis of the fact of the legal of the respect of the legal rules, and the court of appeals, the judge of appeal, will not investigate in the facts? Now, this is a very important issue, because in the case in which the appeal trial is a renewal, a complete renewal of the first instance trial, clearly the accused person can play on somehow has two matches. First match, and if the accused person loses the first match, maybe he might win the second match. So this is something, one approach. A different approach is if the appeal is only for reasons of law. If the first judge, the first court, has committed mistakes at law, and therefore the facts are there, the only problem is to see if the law that has been applied, substantive and procedural law that has been applied correctly. So we will not discuss what happened, what the factual elements. For example, we might discuss the evidence. Could that evidence be brought into the trial or not? Was it admissible evidence? That is a question of law. It's not a question of fact. So maybe the trial the first instance trial has mistaken, and therefore evidence which was used to find the liability, the guilt of the accused, has been used, and that evidence was not admissible. So clearly the judge of appeal, the court of appeal, will have to re-examine the case and set aside that evidence that could not have entered into the trial. So this is again a very delicate issue on the rules when we want to establish a right to appeal, if the judgment, the trial, the appeal trial is on the whole case or only on the strictly legal principles and rules that have been applied in the first instance. And secondly, this right to appeal, is it the right to appeal only of the accused person who has been accused and has been sentenced in first instance, or is it also, does the public prosecution have the right to appeal? That is also somehow a very tricky issue. We see in the US, for example, public prosecution does not have the right to appeal. The accused person who has been found guilty may appeal, but the public prosecution whose claim has been rejected and the accused person has been found not guilty, well, cannot appeal that decision. So just to point out the differences in models, and these models are very very distinctive. When we look at, again, criminal law is a very important aspect of a legal system and gives a whole idea of what are the guarantees that individual citizens have when they encounter this powerful state, which is the sort of criminal law and criminal proceedings. Now, I'll stop here for 1 second. Let's go to chat. So here we have a question by Lucilla Tempesta. I read the question simply because as I'm recording, as these lessons are recorded, and for example, we have Sylvie Shiu, who is in Hong Kong and has, as you can well imagine, has difficulty to follow our lessons because they are obviously they're way around midnight there because of the time zone. So I'm read the question by your questions so they remain on the video, so you know why so the person who listens to the lesson, or it might be you who want to look at the lesson that has been recorded and is on YouTube, you know what is the question I'm answering. So just I don't think I'm stupid just reading the question that has been put to me. So the question by Lucilla Tempesta is, to what is it due the difference between the Anglo-American model and the Continental model regarding the relationship between judge and public prosecution? How did this difference come about? Now, that's a very good question. I will try to answer this in probably today when we look at the notion of jurisdiction, how the judicial order comes out and develops in modern societies. It has very much to do with history and development of history, and how in the continental European model, we followed a certain path, which is, again, it's way back in the 18th century, Prussia, and then afterwards Napoleon. So that is the model. While in the English system, which is picked up by in the US, we see that there's this very clear distinction from the beginning, very clear distinction between the courts and those who have to enforce the law. It's called the sheriff, but anyhow, that's law enforcement. Police, public prosecution, that is the sheriff. When the Habeas Corpus Act of 1689, it's very clear that the sheriff is the king's officer. He is following the orders of the king, and therefore the king has decided that certain things that someone has violated the law and will arrest that person. The control is given by Habeas Corpus Act says, well, when you use that power, well, you may use that power, but you must present the accused person within 3 days. That accused person must be brought in front of the court, because I want to know why that person has been arrested. What are the grounds for depriving this person of his liberty, his freedom? So just to point out, they're very much tied to history and to how the system developed in England and then across the Atlantic in the US, and how it developed, how the system developed in continental Europe. Two histories which have very good, I mean, Beccaria is obviously Italian. His importance in continental Europe is fundamental. Shows that sort of we had sort of maybe different concerns. In England and the US, there were certain concerns, and in continental Europe, we had different concerns. So this is, but we'll see this more specifically when we look at how the judicial order is created in continental European systems and in Anglo-American systems. Now, Cindy Garces asks, how do the parties and the judge choose the members of the jury? Now, you will find it is not the judge that chooses the jury. What is the members of the jury? But also in Italy or in France, there's a list of jurymen or jurywomen. these people are extracted by chance, as if it were lottery, and these people are extracted. And therefore these, so it is not the parties or the judge that choose the members of the jury, but there's an office, an impartial office, which simply extracts the numbers, Mr. Jones, Mrs. White, and so on. What can the public prosecution, or mostly the defendant, do? They can challenge the impartiality of the jury member, saying, for example, this jury member is someone who has publicly expressed his or her views in a certain field. Just think of racial discrimination, crime of someone has been killed because he is colored, he or she is colored, or typically sexual assault against a woman, and who is the jury person has expressed certain views. In the first case has been expressed views which may be racially tainted, and in the second case of saying, well, oh, but you know, women go about with miniskirts, they are asking for it, and so no wonder if someone assaults them sexually. So the whole system is that the parties, public prosecution, and mostly the defendant, try to select a jury which appears to be impartial. So this is a very complex issue. Jury selection is, and again, I refer to you if you want. You can go on Wikipedia, but if you want to amuse yourself, you look at on a whole lot of other movies, not only Law and Order, but a whole lot of LA Legal. You find a whole lot of TV series in which the jury selection, you go on YouTube and say jury selection and see what comes out, and you'll see some very entertaining series on how to select the jury. It's very complex. Has to do with this. Happens only in the U.S. In other countries, as I've mentioned, in continental European countries, the jury is only for very serious crimes, and generally there is no kind of jury selection, except, you know, very someone who's really been very outspoken in one sense or another. It has already, because generally the trial comes much after the arrest and all the investigation. So maybe someone has already expressed on Facebook profile or in some social media has expressed views on how he or she believes if that person is innocent or is guilty, and therefore in that case the person would be prejudiced, and therefore you obviously were biased and therefore is excluded from the jury. But apart from these cases, generally there's much less issue in continental European systems where the jury still exists. If there are no other questions, I will move on to this final part of the module, the relationship between criminal law and criminology. Now, this generally we don't look very much at this when we study criminal law, criminal procedure. This is something that sometimes in some handbooks, it is a few pages are devoted to the issue, but generally it's something that is kept aside because criminology is a branch of the law curricula, which is quite distinct from criminal law, just as legal as forensics, which is very much to do with, obviously, with sort of the relationship between medicine and the causes of the death of someone, investigating the crime scene. Now, where shall I start? Let's start from the basic principle, which is developed throughout, sort of, especially during Enlightenment, Beccaria, and everything that came afterwards. The idea that in order to commit a crime and to exist a crime, they must be mens rea, which is a nice Latin expression, to put it in English, criminal intent. So you must want that crime. You may want it in various ways. It might be a premeditated crime. Someone wants to kill his wife and premeditates how to kill his wife. You find a whole lot of movies of sort of would-be murderers of their spouse, or someone has, because in a fit of rage, has extracted a gun and has shot the person, but obviously the person who shoots knows very well that if you shoot someone, well, you generally kill that person. So there's intent in these cases. So the problem is of criminal intent is one of the elements of a crime. If there's no criminal intent, there's not a crime. There may be something different, but there's not a crime. So we see that when there's negligence, generally speaking, not always, but generally speaking, there's not a crime, but a civil or an administrative wrong. So negligence, generally speaking, as a general rule, is if there's negligence, this is not sufficient to sustain that there's a crime. Let's imagine a case that very clearly someone has a gun and points it to someone else and shoots and kills that person. Someone thinking that the gun is empty, there are no bullets in the gun, and says, listen, this is, I'll just show you how it works, this gun works, and points it to someone else. And instead, the gun is loaded and the person is killed. Well, that is an accident. So we generally, in general criminal law theory, an accident is not a crime. It is because there's no criminal intent. You have done something stupid. You have committed something in which you were negligent, but that is not a crime. You will have other kinds of sanctions, civil sanctions, administrative sanctions, but you will not go under a criminal trial. So one of the issues is trying to establish the person when there is criminal intent, mens rea, and one of the main elements is if the person is considered incompetent. If the person is mentally able, can that person understand what that person is doing? If the person knows what he or she is doing and therefore is able to distinguish good from evil, what you should do and what you should not do, what is the violation of the basic principles of the society if you behave in a certain way and you commit a crime. So this issue of mentally able, so to investigate on mens rea, obviously you have to go into the brain, the mind of the person who has committed the crime. Now, this was generally not considered or was not something that was a real object of investigation by criminal law theory and by the practice. So only in around the mid of the 19th century, so you see it's very late, we see the development of what this medical branch of psychiatry. So we have psychiatry, psychiatrists who are investigating on the mental health of an individual and establishing someone is insane and therefore has to be confined in a mental health institution. If someone is able to understand why, what that person has done or not. So just to point out that this is relatively recent. While a whole lot of principles of criminal law have developed, as we've seen them Magna Carta, so 12, 15, so well, 8 centuries ago, what we are here, we look at this branch of medicine, psychiatry, that starts developing only, well, two centuries ago, mid-19th century, even less than 2 centuries ago. So it is a relatively recent science, and as a matter of fact, now that we go more and more, we try to understand more of, when we look at neurology, and sort of when there's brain surgery, when there's dementia, just think of Alzheimer, we try to understand what are the sort of alterations of the person, someone who is very sane, very intelligent, maybe was some brilliant person, then becomes 80 years old, and then is hit by Alzheimer. We try to understand. We haven't yet understood what are the reasons why someone becomes completely unable to understand anything. So, as you see, this is quite a recent branch of medicine, and we're trying to understand, still trying to understand what happens in the mind of someone, and even more, what happens in the mind of someone who's accused of a crime. Now, here we have, and I again would like to draw your attention as we are in Italy, just to bring you the attention of 3 very important figures worldwide, sort of founders of what we call criminology, and have had sort of very profound influence in the development of criminology in modern times. The first I want to mention is Cesare Lombroso. As you see, it dates 1875, 1909, who is the founder of modern criminology. So psychiatry was the sort of developing those years in the mid of the 19th century, and he started applying this also because he was, for many years, he was the head of certain mental health institutions, trying to apply this to criminal behavior. And Lombroso came out with rather sort of not very conventional, but at those times this branch of knowledge was just starting, this science was really starting, and there was very much uncertainty on this, on the reasons why someone becomes mad, is mad, commits a crime, and so on. And so Lombroso's theory was that there was a genetic origin of a criminal mind. Someone is born a delinquent, and that has to do with his or her genetic structure. So it's something from birth. You are somehow, it is a deterministic approach, and you are a criminal from birth. We shall see that the reasons behind this theory of Lombroso also political. It's rather interesting comparing these, especially Lombroso and Ferri. The point is that subsequent research has demonstrated that, surely, if you are incompetent, you are incompetent from birth, but those are the cases of people who are madness, sort of people who are mentally disabled since their birth. And so we'll set those cases aside because we know that, and that has not to do with genetics, it has to do with other kinds of circumstances. For example, the fact that how the person is born, person has had lack of oxygen during birth and therefore has a permanent reduction of his or her mental ability. So sometimes it's genetic, but many other cases it's not genetic. It has to do with the development in fetus or illnesses that hit the fetus and so on. But the point is this: surely Lombroso's theories have been demonstrated as not being valid. Lombroso was somehow, measuring skulls, taking thousands of photographs. There's a museum which holds all the archive of Lombroso's researches, and they are pretty primitive. And we say, oh, but this is just crazy, measuring the size of the skull of a person to establish if that person is or is not a criminal, or the expression, or the any other facial elements of the person. We know that all this has been scientifically demonstrated as not valid, but Lombroso has substantially set the basis for criminology, in the sense that from that moment onwards, in order to somehow to demonstrate that Lombroso's theories were not correct, and they are not correct, well, criminology has had an enormous amount of development and has tried to investigate what are the real reasons behind the crime. I mean, just someone like the founder of psychoanalysis, Sigmund Freud, well, he studied very carefully what are the works of Cesare Lombroso. And in certain points, he also, he says, well, this is a good intuition by Lombroso. Just to point out that he had a very long-lasting influence on the first steps that psychiatry had in second half of the 19th century, and created this notion of criminology. Now, I was mentioned sort of the political sort of background. Lombroso, as many of these, we shall see the next scholar that we shall see in a moment, was a socialist. I mean, in those times, being a socialist was not something very sort of many people could declare to be socialist, and sort of that means evolution of the working class, rights for the workers, and so on. And so one of the objectives of Lombroso's theory was to say, listen, this person is not a criminal. This is a person who comes from a certain class. Genetically, he is ill, and he must escape. At that time, there was death penalty. He must escape the death penalty or very severe imprisonment. So just the whole idea is, if you see it from a sort of a social and a socialist point of view, criminology was not so much a way to detect what the criminals are, but somehow to find out where there were people who, for a series of reasons, could not avoid committing that crime, and therefore they did not have mens rea. So there was sort of a background, a political background behind Lombroso's theory of sort of genetic origin of the delinquent person. His books are The Delinquent Man and The Delinquent Woman. Those are his main masterpieces at that time, which had enormous diffusion. So the whole idea is that of somehow making more rational criminal punishment, and not a criminal punishment that just hits anybody, but is careful and looks at the personality of the accused person. So the person who has committed a crime, we must try to understand his or her personality. So you see this has pretty strong social and socialist background, which is even more present if we look at well, we'll see it in a moment. So what are the basic principles of criminology? So what do we look? And this is why we want to connect this to to our studies, our legal studies. So criminology studies criminal activities, both individual and organized. You cannot contrast certain crimes and certain criminal organizations if you don't understand how they work. So this is fundamental. So the role of criminology is not only that of investigating crimes, of understanding why someone commits a crime, but it's also understanding how criminal organizations are created, how they operate in order to contrast them better. So this is a very important aspect of criminology. And why do individuals commit crimes? I mean, this is something that we want to understand. Why is it so common that in certain countries men kill their wife or their companion? Why is this happening? What is this? What are the reasons behind these kinds of crimes? So this is something that has to be investigated. If you want to contrast these crimes, obviously these are quite, there's no doubt that someone has committed their crime, generally their crimes, violent crimes, in which then the person sometimes kills himself, or some turns himself into the police saying, I just killed my wife. So it's not the problem so much of evidence, but if we want to avoid these kinds of crimes, of these violent crimes against of men against women, we must try to understand what happens in the mind of those who commit this crime. Why do they commit this crime? So as you see, this is a very important aspect of crime prevention. And then what is the role of society? Family. Obviously, if someone is born in a family where parents are drug peddlers, well, the chances are that the child will somehow get used to some kind of criminal activity. Or education. Has that person gone to school? What kind of education has it received? Social environment. Obviously, if you grow in a certain environment, well, you may have the chances that you somehow engage in criminal activity may be higher, sometimes are higher than if you are in a different social environment. And so what is the influence of these factors in criminal behavior? And then we will look at role of statistics, delinquency rates. So when we say, oh, there's too much crime, what do you mean too much crime? Let's try and look at the rates of delinquency. How many people have been violating lockdown orders? So we say there are 60 million Italians. We take away children who are obviously less than 14. Let's put them aside. Let's put if there are 5 million or 8 million underneath 18 and set them aside. Now, how many of the rest have been violating the lockdown orders? So there have been, let's say, imagine 100 police controls. Out of these 100 police controls, 10 people have been found not having a plausible explanation for being about notwithstanding lockdown. So we will say, well, the delinquency rate in this kind of crime, but it could be a crime, it is an administrative offense, but it could be a crime, well, is of 5%, 2%, 10%. So we are interested in understanding delinquency rates because this allows us to contrast better, to think that this is a major issue or it is a minor issue. Certain crimes are very common. Well, we will do our best to try to reduce them. If some crimes are rather, rare, once upon a time, we've seen lots of Western films in which the main crime was cattle rustling, where people stole huge herds of cattle, and that was a very serious crime. Now, yes, this is something, this is a crime that still exists in many Continental European countries. But are we so concerned that is a cattle rustling a major criminal emergency? We say, no, come on. Yes, obviously, if we find someone that steals cattle, well, we will sanction this person. but it's not, the statistics tell us that this is, well, 0.0001%. So, well, maybe we can focus our contrast to criminality, to criminal activities, and to crimes on different kinds of activities. So just to point out how important these statistics are to understand the rate of delinquency. And also the point is, and this is one of the main results of Lombroso's theory, work, Lombroso pointed out that that there is the notion of crime is dynamic, and therefore certain behaviors are considered quite normal in a certain context, and instead they're considered crime in a different time or in a different region. Just think of those countries, many countries of the world, where if some public authority grants you a contract, you feel historically, you feel obliged to thank the person that has given you this contract and given money, presents or whatnot to that person. Now, this in our society is considered bribery, corruption. So this is a very serious crime. In other societies, this is seen, if you don't do this, well, this is considered, you're very impolite, you haven't followed what is a social obligation. You must thank someone who has given you a contract, the prince or the public official that has given you a contract. So just to point out, and certain crimes are much more relevant in certain periods, in certain ages. Now we see certain crimes which are considered very seriously, which were not considered 50 years ago, were hardly considered. So this rather variable notion of crime, which depends on time and place. So this is just to point out, for example, well, obviously mafia, when we talk about mafia in southern Italy, which is a very serious criminal, creates criminal alarm in many parts of Italy, well, but obviously we would not have, if there's some criminal organization in Sweden or in Finland, we wouldn't say, well, Swedish mafia or Finnish mafia, because the context in which this happens is very, very different. Or just think of drug cartels in Latin America. And so we have to sort of look at criminology tells us that when we talk of criminal law, we have to look at the ages, the moment, the time in which this criminal law is created and applied, and the context, the geographical context in which it is applied. And also we find the fact that the other element of criminology is that suddenly in the courts, the court is not only there to establish if the person is guilty or not, but if the person is mentally able or not. Therefore, we have forensics, psychiatry in trials. Sorry, there's typo here. So, just to close on this point, that insanity does not exclude criminal liability, but excludes criminal sanctions. A person may be found liable for that crime, but will not undergo the typical criminal sanctions, death penalty, because that person was mentally incompetent. Here we see both in models, whether it is the Continental European model or the Anglo-American model, that is Northern Rules of 1843. This person was accused of attempting to kill the British Prime Minister Robert Peel, founder of Bobby, great policeman in London, but killed someone else, and so the problem was to try to establish if that person was competent and incompetent. We see the principles set out by the English judges in that case have been used throughout over nearly 2 centuries, both in the UK and in the US. Certain principles that have been obviously adapted. So the whole idea that the trial is also a trial not only on the facts of the crime, but on the mental ability of the accused person. So this also is another very strong effect of criminology. Then the evolution, as we've seen, that this Lombroso series is not satisfactory because it is because this genetic basis of criminals, of delinquent, is not scientifically is not sustainable. We see it in this development here. We have a very important figure again from Italy, Enrico Ferri, and Enrico Ferri is very interesting because he is an outright socialist. He is elected as a member of parliament of the Socialist Party. He has even been ejected from university. He was teaching criminal law in Pisa University and was kicked out because he was a socialist. Because at those times, well, being a socialist was not such a popular point of view. It was seen as a subversive point of view. And what does Ferri come out with? Two very important aspects. The first point is that criminal sanctions are not only there to protect society, so a general preventive function. We've seen that in Beccaria. So you must prevent sort of that the individual repeats the crime. So individual preventive function and general preventive function. So to give a warning to everybody: if you commit a crime, you will suffer these consequences. But Ferri introduces this fundamental notion we have in our common idea of our criminal systems, modern criminal systems, the rehabilitation of the delinquent person. Therefore, that if you remember, Beccaria talked only of proportion between crime and punishment. Ferri goes well beyond and says, listen, not only must be proportion, but the sanction must be somehow proportionate, must be aimed at rehabilitation. You cannot say that someone, because that person has committed a crime, that person will continue to commit crimes. Somehow you can somehow re-educate the person, rehabilitate the correct person and bring this person back in society. Now again, this is, as you see, there's a very strong social idea behind it, socialist idea behind this. So especially because at those times, well, the working class and those that had not were in a very difficult position and were, if you want more, it was more possible that they fell under the sort of the repression of criminal law rather than sort of white collars respected people who were somehow sort of, were no danger, suffered no danger from the law unless they committed some very serious offenses. So here we find that this very strong evolution of criminology, a humanistic criminology, which points to the rehabilitation of the person who has been found guilty, and then the notion of of victimology, what we call victimology. So sanctions must have the function of, we must look at the victims of the crime, and the sanctions must also look at social individual appeasement. So we must try to understand the point of view of the victims. You cannot only look at the point of view of the delinquents, which is important, their mind. Not only you must look at their rehabilitation, but you must also look at the victims. So this is a very important opening, which is very followed in contemporary times. We shall see this in a moment. And in Garofalo, who is, they generally work together, Ferri and Garofalo. Ferri was a professor and a politician. Garofalo was a very high judge of the Italian judicial system, and he writes this landmark book on the reparation of victims of crime. It is a book which was translated in all languages and sets the basis of why you look at the victims, you must try or sanctions must try to repair the damage they suffered, but at the same time you must try to understand why these people are more likely to become victims, and therefore study the psychology of victims. So this again opens a new page. So when we look at criminal law, for the moment, until Ferri and Garofalo, we were looking mostly at sort of law and order. We're trying to put order and sanction the criminal, then with some reason, with rational attitude, and then from the end of these books, sort of Garofalo's book is 1890, well, we start looking also at the victims and the role of victims in criminal law, and how criminal law should not only look at the criminals, but should also look at the victims. And here we'll finish sort of general laws to protect victims of crimes and groups that are more likely to be victimized. I've mentioned one directive, recent directive, European Union directive on rights, support and protection of victims of crime, then the legislation for compensation of victims of terrorist attacks, and then typically all the legislation we find in all Western countries when it comes to sexual crimes, sort of when women are aggressed, attacked, raped, and the kind of protection, judicial protection, procedural protection that these people must have if you want to somehow not turn them from victims twice, once victims of the delinquent, and secondly victims of the judicial system, which does not look at the victim but looks mostly at the accused person and provides guarantees only for the accused and not for the victim. So this opens a very important point, because when we're looking at modern criminal law, we're not only looking at the accused and the rights for people who are accused to defend themselves, quite rightly with having all the arms to defend themselves, procedural arms to defend themselves, but also the role of victims and how the state the law can protect also the victims and avoid that not only the crimes are repeated, but the victims are victimized again by the judicial machine. And so we see criminology, we are interested in looking at criminology because again, it gives us an idea of how a legal system works if we are looking more at criminals, delinquents, or more at victims, and what is the balance between these two aspects. And especially it opens the sort of the window of lawyers towards other areas, very important areas, sociology, psychiatry, psychology, and statistics. So just to show you that this is something that criminology, and you understand criminal law, especially certain criminal aspects of criminal law, only if you understand what is the criminological background of that crime. Now, I would stop here for today, and as usual, any questions? Are you still there? Or have I been talking to nobody? Everything clear? Well, thank you. Now, so every now and then I have a doubt that I'm sort of speaking, you know, when you think you're speaking to someone, and just like when you speak on the phone, the line is formed, and could you explain the two instances of right of appeal again, Isabella San Marco? Now, this is the idea. Now, once upon a time, let's imagine sort of very ancient times, there's only one trial, and you're found guilty or you're found innocent, and that's it. Then at a certain point, but already this happens already in Roman times. Very interesting. If you look at the trial against Saint Paul, because Saint Paul, who was martyred under Nero, well, he different from Saint Peter. Saint Peter was a Jew. Well, he was a foreigner. Saint Paul was a Roman citizen, and he had a hell of good lawyers, which managed to keep him in life. Well, he was accused, obviously, of trying to overthrow the emperor because of his worship of Christ and creation of this new religion. And he had a whole lot of very good lawyers, which used all the systems of appeals and avoiding him to sort of being sentenced and executed. But finally, then Nero came along and said, well, I'm fed up with this, and that off with his head, because he was a Roman citizen, while St. Peter's was crucified. Now, the right of appeal is something that is, when we have a legal system which is somehow evolved, well, we feel that there may be a mistake in the first decision. So generally we see the right to appeal. Originally, as I've mentioned, the right to appeal was to the sovereign. Let's start from Middle Ages, which makes things simple, and see that the person who's been found guilty could appeal to the king and say, listen, your judges have wrongly decided the case. So please re-examine the case, or pardon me, because I have been a faithful servant of the crown, and I want to be, and I ask your pardon. So there was this appeal, last instance, to the sovereign. Now let's develop this through the centuries, and we see that this becomes a typical judicial aspect. There is always at least one first instance and then an appeal. Now the problem is this trial in appeal. Is this trial a new trial on the facts? So the new judges who are above the first and who can re-examine all the facts of the case and establish if the facts are what have been verified in the first instance, and if the law has been correctly applied in the first instance. So this is the idea of an appeal, which is a new, entirely new trial. Let's put it in a football idea. There's two matches. There's a first match, and you do it at one team loses, and then there's another match in another a subsequent match in another field. So there are two completely different trials, and if you win in the second trial, well, you've won the case. In the other system, which is mostly Anglo-American system, not only, but mostly, the second trial, the appeal, is not on the whole facts. The court, which is the Court of Appeal, is not there to examine if the facts are or are not. The court is there to examine if A, evidence has been correctly introduced, therefore maybe there's been inadmissible evidence which has been given to the jury, or the judge has used evidence which is inadmissible. Just think of hearsay, or someone who could not give evidence because of the relationship that this person had with the accused, and so on. So, first of all, the appeal will see if evidence has been correctly introduced in the case, then will not decide if that evidence is in one sense or another, but will simply decide if it has been correctly introduced in the case. And secondly, if the law that has been applied correctly, because as we know, law is a fact of interpretation, especially criminal law. We have to see how it is interpreted. So if the court, first instance, has interpreted the law in a wrong way, has given to the words a certain interpretation which is the wrong interpretation, well, the Court of Appeal would put things straight and say the first instance erred, made a mistake in the application of the law. So these are the two ways of appeal. So an appeal which is a new match between prosecution and defense, and who wins as the second match should win the whole trial. Therefore, you are definitely acquitted or definitely found guilty, or instead a second trial, which is only on strictly legal issues and not on factual issues. They're not going to investigate, bring new evidence inside the trial and see if there's new evidence which can bring to the declaration of guiltiness or innocence of the accused. I hope this makes it sufficiently clear, Marco. If there are no more questions, well, thank you all, and see you next Monday, and we will start examining instead jurisdiction, which is a very important issue in comparing legal systems and understanding how jurisdiction works. Oh, Zinai has a question about exams. Just to point out, today, just before the lesson, we had a faculty meeting, and the director of the department, Professor Seizures, said, listen, I know what told us professors and told the student representatives, said, listen, I know we all want to know about exams. For the moment, I cannot tell you anything because, now I'll give you just the university as a whole must decide how the exams are going to be made. Because the main concern that the university has is how to ensure a certain safe environment from a medical sanitary point of view, and therefore, for example, how do you enter? Now, when you come to our faculty, you can come in, you have many entrances, one entrance there, another one there, many entrances, many doors. So how do you ensure that you can enter only, for example, if there is a temperature scan? Can we put a temperature scan to see if someone has a temperature and therefore this person cannot be admitted? Should we put hygienic dispensers to clean hands, gloves, and so on? Now, these are very complex practical aspects, which the university, as you know, Roma 3 we have 12 departments, and they're all dislocated not in one building. I mean, the law department is there, but next door at number 139, we have other 2 departments which are there. Then there's engineering, there's natural sciences, then there's architecture, there's pedagogy, there's further on in the Ostiense, there's humanities, so then political science, business school. So if you think of all the buildings, so it's a very complex issue. So it isn't that you can solve this issue only for the law department. We would like, obviously, we would like this to be solved, but clearly there's a general issue which concerns 40,000 students, which are all those enrolled at Roma Tre. So what will be happening is that we are trying to understand, the sort of the governing bodies of the university are trying to understand how, once the lockdown finishes, in the months of, at least the months of June and July, how you can give access to students, avoiding that subsequently you incur in some kind of liability. Because I can assure you, if you have a look at that link that I gave you, that I generally put at the bottom of my mails of this website I'm somehow organizing, comparative COVID law, well, you see that there are already sort of some kind of claims against the state, for example, for not having prevented contagion and so on. So the governing bodies of the university are very concerned, as governing bodies of all universities, that someone may come tomorrow saying, hey, listen, I was obliged to come to Roma Tre to take this exam, and I was I fell ill, and therefore liability is that of Roma Tre University. So just as you see, I brought the discussion on a very legal approach, but we are lawyers, and so we must have this kind of approach. So unfortunately, I'm unable to give you indications. I would like to know. I know how I would like the exam to be held. I've already given these indications to the director of the department, but obviously I cannot give you tell you anything now. I will have to wait for what are the indications, general indications, which concern all 12 departments of the Roma Tre University. For the moment, I cannot tell you more than this. But this is fresh news, and this is what the director of the department told us well an hour before we started lesson. So I know Zinai is not satisfied by this.
No, wait, can you hear me?
Yes, I can.
Okay. No, the question was more of a sort of issue, because I noticed that in the list of exams, there's introduction to comparative legal systems, but there's not the 9 ECTS.
No, don't be mistaken. It is very clear. Now, introduction to comparative legal systems is a 7-credit course, which is within the Studying Law at Roma Tre program, and this is what our Erasmus students, Anzalone, Locascio, Kidd, Munday, Wood, Shiu are taking. That is, our foreign students, our Erasmus students are taking that exam, which is a 7-credit exam, which is Introduction to Comparative Legal Systems. The exam that the course that you Italian students, Roma Tre students are taking is Comparative Legal Systems, and that is a 9-credit course. It is, you find very distinct. If you go, you will see that there are 2 different syllabuses. One is the syllabus of the 7-credit course, and the other one is of the 9-credit, and you will see that the 9-credit has an additional part. Originally, when I thought of this in autumn, I added additional part devoted to Brexit, which I think is a very important issue in legal issue, and it's important we discuss this. But I probably think that when we end in May, when we're going towards the end, maybe, but I'll discuss this with you. We will see if the special part, which is not the part that the Erasmus students will be following, whether we shall do something more that has more actual, for example, some aspects of the coronavirus pandemic. But I would wait. But if you look on the website, it's very clearly indicated: Introduction to Comparative Legal Systems, which is a Studying Law at Roma Tre course, which goes to the Erasmus students, and Comparative Legal Systems, which is belongs to the global legal systems GLS program. Hope that is clear, Zinai. Okay.
Thank you.
Then see you next Monday. Take care, and let's hope we've gone 1 week. That will be the last week of lockdown. So maybe we can next week, sort of on Wednesday, we can sort of, at least we know that on Monday the 4th, maybe we will be free again, at least to go with carefully, attentively. We will be able to go out of house, at least for Italian students, and I don't know, lockdown in other countries, whether it's Hong Kong or Belgium or UK, when the lockdown will end. But just to say, we've got through another week. We still have another week for lockdown. Good. Take care and good afternoon to everyone.